Warm greetings everyone. I am Dr. Pawandeep Kaur from Khalsa College of Law, Amritsar. The topic of our today's talk is meaning and nature of interpretation of statutes. Dear friends, after going through today's module, you will be able to understand the meaning of statute, interpretation of statutes, and nature of interpretation of statutes. Dear learners, the present module is divided into 5 parts. In the first part of this module, we will discuss the meaning and definition of statutes and interpretation of statutes. The second part of this module talks about need and importance of interpretation of statutes. In the third part of this module, we will discuss nature of interpretation of statutes as a creative function. In the fourth part of this module, I will put light upon the nature of interpretation of statutes as an art and science. And in the fifth part of this module, we will discuss the jurisprudential aspect of the nature of interpretation of statutes. So friends, let us start with brief introduction of the topic. The language employed in enacted laws, particularly the contemporary acts and rules, is meant to be highly technical and allow limited opportunity for interpretation or construction. However, everyone's experience, including those who must share the burden of enforcing the law, has been unique. Therefore, the interpretation of statutes become a necessary tool. One of the most substantial and principal duties vested in the judiciary is the interpretation of statutes or laws that are in force. When the courts deliver justice in a legal dispute, they strictly abide by the boundaries framed by the legal frameworks which encompasses certain laws, statutes, the constitution, and the delegated legislation. The legal framework of a democratic country like India includes a plethora of legislations and regulations. The legislature, with the compliances of procedural parliamentary rules, formulates and drafts certain written statutes and legislations. The courts deliver justice in a legal matter by interpreting the underlying principles in these legislations. The written laws are substantiated by the courts and justice is administered by the courts through the pronouncement of a verdict over the legal dispute. To interpret statutes and to prevent any wrongful interpretation of the laws, the court should follow certain rules to shape these laws. So, one of the most basic rules of interpretation is the literal rule of interpretation of statutes, where the court interprets the wordings of the law as it is. However, there may be certain loopholes that may be found in the law due to which it is not interpret a straightforward understanding of the language of the statutes. It may lead to ambiguity and absurdity if the courts interpret the natural meaning of the language used in the statute. Dear friends, moving further, the first task is to understand the meaning of statute. A statute is a formal written enactment of a legislative body. Typically, statutes command or prohibit something or declare policy. Statutes are laws made by legislative bodies. They are distinguished from case law or precedent, which is decided by courts, regulations issued by government agencies, and oral or customary law. Statutes may originate with the legislative body of a country, state or province, county or municipality. The word statute is derived from the Latin word statute, which means law or decree. Definition of statutes according to Maxwell. Statute has been defined as the will of the legislature. Normally, it denotes the act enacted by the legislature. A statute is thus a written will of the legislature expressed according to the form necessary to constitute it as a law of the state and rendered authentic by certain prescribed forms and solemnities. Further, According to Bowyer's Law Dictionary, a statute is a law established by the act of the legislative power, that is, an act of the legislature. The written will of the legislature. The term statute is generally applied to laws and regulation of every sort law which ordains, permits, or prohibits anything which is designated as a statute, without considering from what source it arises. The Constitution of India does not use the term statute, but it employs the term law to describe an exercise of legislative power. Dear friends, now I would like to put a light upon kinds of statutes. The classification helps in understanding the various functions and applications of statutes within the legal system. Here is a list of kinds of statutes. First one is substantive statutes. These statutes define rights and duties, for example, criminal laws and property laws. Further, procedural statutes. These statutes outline the processes for enforcing rights, for example, rule of civil and criminal procedure. Moving further, public statutes affect the general public, for example, tax laws, environmental regulations, etc. Next one is private statutes. These apply to specific individuals or entities. For example, law of a particular company. Another one is enabling statutes. These statutes grant authority to governmental bodies or agencies, for example, regulatory statutes. Further, recessional statutes. These statutes repeal or amend existing laws. Further, uniform laws intended for adoption across multiple jurisdictions for consistency. For example, Uniform Civil Code. Code statutes organized into comprehensive codes, for example, Penal Code, Civil Code. Further, appropriation statutes. These kinds of statutes allocate funds for government spending. Further, emergency statutes. These statutes enacted in response to urgent situations, for example, public health emergencies, etc. Dear friends, moving further, the next is meaning of interpretation of statutes. The term has been derived from Latin term interpretare, which means to explain, expound, understand, or translate. Thus, interpretation is the process that is employed by the judiciary to ascertain or to determine the meaning of the statutes or legal provisions. The objective of the court is not only merely to read the law but also to apply it in a meaningful manner to suit from case to case. It is also used for ascertaining the actual connotation of any act or document with the actual intention of the legislature. It is often referred to as the art of finding out the true sense of an enactment by giving the words of the enactment their natural and ordinary meaning. Further, definition of interpretation of statutes. According to Salmond, interpretation and construction is the process by which the court seeks to ascertain the meaning of the legislature through the medium of authoritative forms in which it is expressed. According to Blackstone, the most fair and rational method for interpreting a statute is by exploring the intention of the legislature through text, the subject matter, the effect and consequences, or the spirit and reason of law. According to Cooley, interpretation is an art of finding out the true sense of any form of words and enabling others to derive from them the same meaning that the author intended to convey. Dear students, it is pertinent to know about need and importance of interpretation of statutes. In C. Ford Courts Estate Limited versus Asher, Justice Denning explained the need for statutory interpretation is instructive. It is not within human powers to foresee the manifold sets of facts that may arise, and that even if it were, it is not possible to provide for them in terms free from all ambiguity. The English language is not an instrument of mathematical precision. Our literature would be much poorer if it were. This is where the draftsmen of Acts of Parliament have often been unfairly criticized. A judge, believing himself to be fettered by the supposed rule that he must look to the language and nothing else, laments that the draftsmen have not provided for this or that, or have been guilty of some or other ambiguity. It would certainly save the judges trouble if Acts of Parliament were drafted with divine, precise, and perfect clarity. In the absence of it, when a defect appears, a judge cannot simply fold his hands and blame the draftsman. He must set to work on the constructive task of finding the intention of the Parliament, and he must do this not only from the language of the statute but also from the consideration of the social conditions which gave rise to it and the mischief which it was passed to remedy. And then he must supplement the written word to give force and life to intention of the legislature. To put into other words, judge should ask himself the question: if the makers of the act had themselves come across this luck in the texture of it, how would they have straightened it out? He must then do as they would have done. Judge must not alter the material of which it is woven, but he can and should iron out the creases. The object of interpretation has been explained in Halsbury's Law of England. The object of all interpretation of written document is to discover the intention of the author, the written declaration of whose mind the document is always considered to be. Consequently, the construction must be as near to the minds and apparent intention of the parties as possible and as the law will permit. The function of the court is to ascertain what the parties meant by the words which they have used, to declare the meaning of what is written in the instrument, and not of what was intended to have been written. To give effect to the intention as expressed, the expressed meaning being, for interpretation, equivalent of the intention. Dear students, it is not possible to guess at the intention of the parties and substitute the presumed for the expressed intention. The ordinary rules of construction must be applied, although by doing so the real intention of the parties may in some instances be defeated. Such a course tends to establish a greater degree of certainty in the administration of the law. The object of interpretation thus in all cases is to see what is the intention expressed by the words used. The words of the statute are to be interpreted to ascertain the minds of the legislature from the natural and grammatical meaning of the words which it has used. According to Salmond, interpretation or construction is the process by which courts seek to ascertain the meaning of the legislature through the medium of the authoritative forms in which it is expressed. The process of understanding the meaning of law or legal provisions is known as interpretation. It is an aspect of our system enabling courts and other bodies involving in adjudication to apply the law to specific cases and resolve legal disputes fairly. Interpretation plays a role in preventing the exercise of power and ensuring that duties are fulfilled. If a statute is written in ambiguous language, government officials may interpret it in ways that allow them to wield their powers arbitrarily. However, When courts interpret statutes, they can ensure fair application of the law while preventing abuse of power by the government officials. Interpretation is also instrumental in preventing crime and safeguarding welfare. If criminal statutes are interpreted narrowly, they may not effectively deter crime. Conversely, if they are interpreted broadly, individual rights may be violated. Courts have a role to play in interpreting statutes in a manner that both prevents crime and safeguards individual rights. Lastly, interpretation contributes to expediting the delivery of justice. If the courts struggle to promptly and accurately understand the law, it can result in delays with the proceedings. Such delays can have effects on both plaintiffs and defendants, eroding trust in the judicial system. To grant justice, courts should establish consistent guidelines for interpreting the law. Dear friends, in this part of the module, we will discuss the nature of interpretation of statutes as a creative function. Essentially, considering statutory interpretation as a creative function emphasizes the significance of interpretation in the continuing evolution of legal principles by acknowledging the dynamic interplay between judiciary, society, and law. The interpretation of statutes as a creative function highlights the active role that judges and legal practitioners play in shaping the application of the law. Here are some key points regarding this perspective. First one is judicial discretion. Interpretation statutes often requires judges to exercise discretion, especially when faced with ambiguous languages. This discretion allows judges to influence how laws are applied in specific cases. Further, filling gaps. Statutes may not address every possible situation, leaving gaps that require interpretation. Judges creatively fill these gaps, ensuring that law remains relevant and applicable. Further, adapting to social change. Laws can become outdated as society evolves. Judicial interpretation allows the law to adapt by applying statutes in ways that reflect current values and norms. Further, balancing competing interests. Courts often face cases involving conflicting rights or interests. Through interpretations, judges can creatively balance these interests, arriving at the solution that serves justice. Further, innovative applications. Judges can apply existing statutes in novel ways, leading to new legal principles and precedents that can influence future cases and legislation. Further, constructing legislative intent. Interpreters often delve into legislative history and context to ascertain the intent behind a statute, which involves creative reasoning to reconstruct the lawmaker's objectives. Further, contextual analysis. Understanding a statute about other laws and societal norms requires creative thinking. This contextual approach helps to clarify ambiguous provisions and ensure coherent legal interpretation. Further, judicial activism versus judicial restraint. The creative nature of interpretation can lead to debates about the judicial activism, where judges take an expansive view of their role, versus judicial restraint, where they adhere closely to the text. Further, influence on future legislation. Judicial interpretation can prompt legislative changes, reflecting how courts creatively shape the law through their rulings and applications. Moving further, moral and ethical considerations. Judges may incorporate moral reasoning into their interpretations, ensuring that application of the law align with societal values and ethical consideration. Dear friends, moving further, the next one is nature of interpretation of statutes as an art and science. Viewing statutory interpretation as both an art and a science captures the complexity of legal reasoning. It recognizes the importance of systematic analysis and logical consistency, while also valuing creativity, context, and human experience. This duality is essential for the effective application of law in a dynamic society. The interpretation of statute is often described as both an art and a science, reflecting the complex and multifaceted nature of legal analysis. Here is how these two perspectives apply. As a science, systematic approach, statutory interpretation involves established methodologies and rules, much like scientific method. Legal practitioners follow specific principles and canons of construction to analyze text. Logical reasoning. Dear friends, interpretation requires logical reasoning and analytical skills to deduce meaning from statutory language and structure. This analytical rigor aligns with scientific inquiry. And further, the most important one is predictability. The use of consistent interpretive methods aims to produce predictable outcomes in legal reasoning, akin to scientific principles that yield consistent results. Further, empirical data. Courts may analyze case law, legislative history, and empirical evidence to inform their interpretations, similar to how scientists rely on data to support their hypotheses. Frameworks and models. Legal theories and frameworks like textualism and purposivism provide structured models for interpretation, much like scientific theories that guide research. Moving further, interpretation as an art. Creativity and discretion. Interpretation often requires creative thinking to address ambiguities, gaps, or novel situations not explicitly covered by statutes. Judges may exercise discretion to shape legal outcomes. Further, contextual understanding. An effective interpretation considers the broader context, including societal behavior, historical background, and the implication of law, requiring an intuitive grasp of implication. Balancing competing interests. Judges often navigate conflicting rights and interests, requiring sensitivity and an artful balancing act that cannot be strictly codified. Further, emotional and ethical dimensions. Dear friends, interpretation can involve moral reasoning and ethical consideration, where judges must weigh the human impact of their decisions, reflecting an artistic sensibility. Further, narrative construction. Judges and lawyers often craft narratives around statutes and their applications, using persuasive language and storytelling techniques that resonate with broader human experiences. Dear students, moving further, at the last but not the least, the jurisprudential aspect of nature of interpretation of statutes. The jurisprudential aspect of statutory interpretation encompasses a wide range of theories and philosophies that inform how laws are understood and applied. This interplay between legal theory and practical interpretation is crucial for achieving justice and ensuring that statutes serve their intended purpose in society. The jurisprudential aspect of statutory interpretation examines the philosophical and theoretical foundations that guide how laws are understood and applied. Here are some key elements. Legal positivism. This legal positivism emphasizes the importance of written law and its clear meaning. According to legal positivists, the role of interpretation should be limited to applying the law as it is written, without considering moral or social implications. Natural law. This law suggests that laws should align with the moral principles. In this view, interpretation involves not just understanding the text, but ensuring that its application reflects broader ethical standards and justice. Next one is intentionalism. This focuses on recognizing the intent of the lawmakers. This approach argues that understanding the purpose behind a statute is essential for its proper application, thus requiring interpretation that align with legislative goals. Further, purposivism. This related to intentionalism. Purposivism seeks to interpret statutes in a way that fulfills their intended purpose, even if it requires going beyond the literal meaning of the words used. Further, textualism. This advocates for a strict interpretation based on the text ordinary meaning. Textualists argue that role of judges is to apply law as it is written, avoiding subjective interpretations based on intent or purpose. Further, contextualism. This recognizes the importance of context in understanding a statute. This perspective examines how a statute fits with the broader legal framework, including related laws and societal conditions. And further, judicial activism and restraint. This explores the debate over how much discretion judges should have in interpreting statutes. Judicial activism favors a more expansive role for judges in shaping law through interpretation, while judicial restraint emphasizing adherence to text and legislative intent. Further, role of precedent. The principle of stare decisis requires courts to follow established precedents. The jurisprudential aspect of interpretation examines how past decisions influence current interpretations and development of legal doctrines. Theories of justice. Different philosophical theories of justice, for example, distributive justice and corrective justice, influence how statutes are interpreted and applied, particularly in cases involving social rights and equity. Further, societal and cultural influences. Jurisprudence considers how societal values, cultural context, and historical circumstances impact statutory interpretation, shaping how laws are understood in different contexts. So, dear friends, now I would like to conclude by saying that interpreting statute is an intricate responsibility within the system. It plays a role in enabling courts and order adjudicating bodies to apply the law to individual cases and resolve legal disputes. These guidelines are designed to ensure the consistent application of the law, maintain its relevance and effectiveness, and uphold justice. In addition to these rules and principles, lawyers also utilize external aids for interpretation. These aids assist lawyers in comprehending the meaning and purpose behind a statute, allowing them to determine its interpretation. Interpreting statutes is undoubtedly complex but undeniably vital with our system. So friends, with this, we will end today's talk. We'll see you in the next module. Thank you so much.